We will go on the record in the matters 20 CM 234, 21 CF 130, 21 CM 199, State of Wisconsin versus Benjamin Flannery. The state appears through DOC agent Leah Lineweber. We have Mr. Flannery in person as well. We're set here today for a probation review hearing. We were here on February 19th, in which the court did provide specific orders and conditions for Mr. Flannery to meet to avoid having conditional jail. He was serving some.
Welcome back to Judge Point. If you love real courtroom drama, subscribe now and never miss a case breakdown. Today, we're diving into the tense probation review hearing of State of Wisconsin versus Benjamin Flannery. The judge had already given him strict conditions to avoid jail, but this was his second chance, slipping away. As the hearing unfolds, Benjamin admits to violating the rules, leaving the court with little patience. Let's break down how this escalated into 90 days of conditional jail.
Conditional jail or in custody on a warrant and facing conditional jail. At that time, the Department of Corrections had another individual, Gretchen Annabis, in your place, Ms. Lineweber. That is not the agent of record. You were on vacation. And so she had notes about the case, and there was a recommendation from your standpoint and Department of Corrections standpoint. But now you are back from vacation, and you can provide the court with an update on where we are now from February 19th and where Mr. Flannery is.
In February, Benjamin Flannery faced a serious ultimatum: follow probation conditions or serve jail time. The judge was clear: absolute sobriety, payments, and progress on education. Yet less than 2 weeks later, Benjamin admitted to meth use. The probation agent confirmed his slip-ups, including a later positive marijuana test. Despite reminders, he failed to provide job logs as ordered. Each missed step tightened the court's scrutiny, setting the stage for a heated showdown over his repeated non-compliance.
He did come back on the 14th, and he was positive for marijuana, and he stated that it was not new use. But I did not realize at that time that he didn't test positive, or he didn't admit to it when he came into the office the first time. So I believe it was probably new use, but he was negative for methamphetamines at that time. He has not handed in any of the job logs, but he did state that he was hired full-time with his wife's uncle, I believe. He was told that he needed to bring in documentation, like fill out the days and the times and have the boss sign it, verifying that that's what he worked. And he was supposed to bring it to court today.
The probation agent explained that Benjamin did show up to meetings and even filled out GED boot camp paperwork, but progress stalled quickly. He tested positive for substances and failed to provide job verification. Though he claimed he had steady work with his uncle-in-law, no documentation reached the court. Payments were coming in small increments, but the amount owed remained high. For the judge, it was a pattern: excuses instead of accountability, and half steps instead of progress.
Mr. Flannery. All right, so you were here in court on the 19th. You then saw your DOC agent on the 28th, and you admitted to consuming methamphetamine, correct?
Correct.
So from February 19th, in which you were in court, and the court set very strict conditions and did not order conditional jail, you used methamphetamine between February 19th and February 28th. Correct?
Yep.
And then between February 19th and...
The courtroom tension grew when the judge pressed Benjamin on his admitted drug use. February 19th's leniency meant nothing when, within days, he consumed methamphetamine and marijuana. The judge reminded him that sobriety was not optional. It was a core probation condition. Benjamin tried to downplay his choices, calling them a slip-up. But his bloodshot eyes and defensive answers made the judge more skeptical. Each word pushed him closer toward the inevitable outcome: conditional jail time.
Understand that?
Yes, I do.
Okay, and so now we have two admitted uses of not only THC, but methamphetamine. And we're talking February 19th to February 28th is not that long in time, right?
Right.
Ms. Lineweber, is there a recommendation from Department of Corrections?
There was not.
You don't have a recommendation?
No, I'm sorry. I just assumed we would bring it to you and then you would decide what you
Okay.
wanted to do.
Mr. Flannery, is there anything that you want to tell the court or you want to let me know?
Benjamin insisted that now, with full-time work, he could pay his dues. He pointed to his uncle-in-law's construction company as proof of stability, but when the judge recognized the name and asked for documentation, none was produced. His promises rang hollow without evidence. The court's patience, once lenient, was fading. Even with some payments made, the larger picture showed missed opportunities, broken commitments, and probation violations stacking higher. The chance to prove responsibility was slipping beyond reach.
Prior to the last probation hearing. At least I thought there was. Maybe it was just what Ms. Annabus told the court. Did you file a memorandum prior to the last hearing?
I did requesting the hearing.
Requesting the hearing. Do you remember what date that was?
I do not. I'm sorry.
Oh, that's okay. Oh, was that in December?
It very well could have been.
Yes. December 23rd, 2024 was a memorandum requesting a hearing.
Probation records revealed a troubling history. Unpaid fees, missed educational requirements, and no completion of AODA treatment. These failures echoed back to December, when a memorandum had first flagged Benjamin's non-compliance. Despite repeated reminders, progress was minimal. The judge weighed this history against Benjamin's new admissions of drug use. Each failed step showed a pattern of disregard for probation orders. This wasn't just one mistake. It was an ongoing cycle, convincing the judge that enough was enough.
Right now, 90 days conditional jail.
Can I get one more?
Nope, you're all done. I gave it to you on
I've
February
been- no.
19th. You're all done, 90 days.
Come on, I'm just getting my
90
stuff
days.
together. I've been doing,
I gave you leniency on
give me
February
a chance at
19th.
least to,
I gave you a chance
I
on
know,
February
but
19th.
please, come on,
I
please.
gave you your chance on
Judge,
February 19th.
please.
You have not done your AODA since I sentenced you, Mr. Flannery.
You said
did I
about the
sentence you?
AODA,
When did I sentence you?
you said about AODA, remember you said we're gonna just put that aside right
If
now and worry about the
you're
other stuff.
clean.
We'll worry about the other things. Okay, so I'll
you were-
do that.
When the judge announced 90 days of conditional jail, Benjamin pleaded desperately for another chance. He insisted he was getting it together and even promised to start AODA treatment. But the judge was unmoved. February's leniency had been his opportunity, and he squandered it. As Benjamin begged and argued, the judge's tone hardened. His swearing and frustration only sealed the outcome. The courtroom shifted from negotiation to finality. 90 days behind bars, effective immediately.
AODA.
Nope,
I'll do the AODA then.
90 days.
I'm
Bring him
signed up
upstairs.
to do my
We're
GED.
adjourned.
Your Honor, please, come on.
90 days.
No. Come on, please.
90 days. 100 days.
What?
You just swore 100 days.
The hearing closed with Benjamin escorted into custody. His last-minute pleas and promises couldn't erase weeks of failed compliance. For the court, this was a story of leniency met with repeated violations, ending in a stern reminder: probation is a chance, not a guarantee. On Judge Point, we break down the cases that reveal real human struggles and courtroom drama. Like this video, subscribe for more, and stay tuned for the next compelling case that will leave you thinking long after it ends.